On physical education and tort law. And given my current capacity as a physical education teacher educator, I found this area of the law to be very applicable and relevant to not only my studies, but in which the field I am currently working. And I hope this information can be useful for future teachers. Um, in today's presentation, we will um, discuss, what tort law is, intentional versus unintentional torts, negligence, some real life examples of how physical education teachers found themselves in the midst of lawsuits and litigation, and then some strategies for minimizing any type of safety and litigation risk. I think it's important to remember that physical education is unlike traditional subjects where students are engaged in various forms of play. And with that comes with a greater chance of students becoming injured or harmed. And students, getting um, little bumps and bruises and getting injured in physical education classes isn't necessarily against the law. However, if a student is injured um, because the physical education teacher could have taken action to avoid that injury, then that might be a problem. So I hope in this presentation we can discuss some specifics about how to avoid foreseeable dangers. And so I hope this information is relevant to aspiring teachers and to help them better understand the avoidable dangers that is associated with our content and with our field, and when these dangers and injuries do occur, the importance of having a plan in handling them. So I hope you enjoyed the presentation. So what is tort law? Well, a tort means just simply a civil wrong. Um, According to Dayton 2019, tort contract is an implied social contract to act reasonably in interactions with others. So certainly every educator and teacher has, um, you know, a kind of tort contract, right? That you're going to interact reasonably with the students that you teach. And so when we talk about, lawsuits involving tort, we usually see where it's civil law, right? And typically what happens is, there's a plaintiff or a victim who has been maybe, you know, experienced some type of bodily harm or injury due to maybe a negligence of an educator, and therefore they are seeking monetary damages or for those damages. So when we talk about proving any type of civil law, we talk about having a preponderance of the evidence, meaning, to win that civil suit, it would require proof of the plaintiff's tort claim by a preponderance of the evidence, which means that the plaintiff meets this burden of proof by presenting physical and testimonial evidence to prove their case, and that the proposition that it is more likely to be true than not true that that defendant caused the harm. And so it's really kind of a step below um, prosecuting criminal law, right? Because in criminal law, all defendants proven innocent, or excuse me, are innocent until proven guilty. And so, for a prosecutor to prove that the law was indeed broken, they have to prove the defendant's guilt beyond a reasonable doubt. That there's just all the evidence in testimony points to that defendant committing the crime beyond a reasonable doubt. And so the two, just because they have separate, um, ways of prosecution or proving guilt, doesn't necessarily mean that they can't be associated together. And so there are some instances where defendants are prosecuted for breaking both criminal and tort law. So let's say, for example, a physical education teacher gets upset with an unruly student and physically hits the defendant and causes bodily harm. Well, that teacher would certainly be charged with, a battery crime, and the victim could also file a separate civil suit against the defendant or school district, um, due to that tort law violation, um, and they could be seeking monetary damages. And so when we talk about um, omission and commission, omission means a crime of omission is when a person fails to act when he or she is required to act. It's their responsibility. And a perfect example of that would be child neglect or failure to um, you know maybe attend a jury duty if we're getting off topic. But a crime of commission means crimes of commission is when a person does something against the law. They murder, they steal, they break the law. And so most tort cases concerning schools involve, negligence or unintended claims. And so negligence is the failure to use ordinary care. And generally speaking, most tort law cases involve schools when the plaintiff is a student, parent, or a community member who is seeking monetary damages for some harm that was allegedly caused by the negligence of the defendant, school officials, or those under their supervision. And so that's when we really kind of get into that tort being either intentional or unintentional. And we will talk a little bit more about that now. And so, when we talk about intentional tort, that's, torts are committed with the purpose of causing the harm or knowledge to a substantially certainty that harm would follow. And so when we talk about, really common ones involving physical education or education in general, here are some of the intentional torts. Assault, right? An assault, it occurs when the defendant acts with the intent of causing apprehension of bodily harm or offense by the plaintiff, right? So it's almost essentially kind of a threat, which really makes that victim really feel, emotionally threatened. But battery, on the other hand, is the actual and intentional infliction of harmful or offensive bodily contact. So right now the actual harm has been done, and so those are, the differences. So if a physical education teacher, gets upset with the student who is refusing to run the mile and says, "I'm going to hit you," but doesn't actually carry it out, that could be a form of assault. And proving that, you have to prove primia facie of assault requires the plaintiff to establish a preponderance of the evidence that there was an action the defendant intended to cause apprehension, and that it indeed caused apprehension, right? So that action of that threat, maybe didn't necessarily cause physical damage, but it certainly could have caused emotional damage to that student. And so when we talk about battery, right, say you got that PE teacher who, same situation where the student's refusing to run the mile, and then they threaten to hit that student and actually carry it out and strikes that student, that would indeed be a battery. And how you, prove that is also, again, by proving primia facie of, battery requires the plaintiff to establish a preponderance of the evidence that there was an action by the defendant intended to inflict harmful or offensive bodily touching that indeed resulted in this type of bodily touching. And so, this is where we could talk about physical abuse, but also even type of sexual abuse or harassment as well. And so other issues that sometimes, occur when we talk about intentional torts are, false imprisonment, where, say you have you're upset with the student and you throw them in the PE equipment closet and you lock them in there. Well, that would be a false imprisonment. You're putting that student in a place where they did not consent to go as a form of punishment, and that would certainly be a violation of, the law. Invasion of privacy, and this one's really kind of important when we talk about physical education, because especially in the secondary schools, there's requirements for the students to dress out into physical education clothing. And so, they have to obviously do that in a locker room. But, while locker rooms need to be supervised, right, you can't be, invading somebody's privacy, recording somebody changing in the locker would certainly in the locker room would be certainly an invasion of privacy. And then we talk about our last one, some intentional emotional distress. This could be just a physical education teacher bullying or chastising an obese student, for example. So these are some of the intentional torts that we see. I think one thing that's really important to know is medical treatment because of this risk of greater injury. Sometimes students are going to get hurt and need some type of medical treatment. Well, it should be known that medical treatment given without consent is a battery. So, for example, you have a student who's complaining about a migraine before a basketball lesson you're teaching. Well, you want that student to participate, and you've got some ibuprofen in your office, so you're gonna you go and give that student a couple, and then the result of that is the student having an allergic reaction that causes bodily harm. Well, you could be certainly charged with a battery. You could also be charged with, again, a violation of tort law, and a civil suit ensues. That's not your job as the physical education teacher, where you should be sending that student to a nurse. And that doesn't necessarily mean that you don't do anything if a student gets in trouble gets injured, because you do have an obligation to act within reasonable care. So say, for example, it's that same basketball lesson, right? And you've got a student who collapses in the middle of it and, isn't breathing. So you take action by administering CPR, and you get the AED out and attempt to, restart that student's heart. Well, say, you're able to do that, but that does cause the student some type of bodily damage due to that accident. You are protected. You are protected under Good Samaritan statutes because of an emergency situation where that student's life was being threatened. And so, according to Good Samaritan statutes, a bystander acting in good faith, attempting to perform first aid, CPR, or rescue using an AED cannot be held civilly liable for unintentional harm caused to a victim while attempting to resuscitate or otherwise perform life-saving aid. And actually, this happened in Athens, not this year, but the year before, in the spring of 2019, where the physical education teacher at Fowler Drive had to come and use an AED to revive a student whose heart stopped on the playground, and she did that, and the student was actually saved. So, because we often, on a graduation requirement is getting our students to have a CPR and AED training, don't think that this couldn't happen to you, as it certainly has happened here in our own town with the physical education teacher. So you just want to be prepared, but you also want to know that, you're not going to be litigated for trying to save a student's life. And there are laws that protect you. So let's look at an example of a intentional tort. And so this one happened in 2015, IBEL versus Laguna Beach Unified School District. And I will make it clear that I did not see the ruling on the final ruling on this. But let me tell there certainly was a lawsuit that was formed and happened. So this was filed against a middle school physical education teacher, claiming that the teacher mocked a student for being overweight and forced him to participate in exercise, despite doctor's notes excusing the boy from class. And so it was said that the teacher had hurled insults out at this student, calling him a heavyset, calling him fat, big boobs, and squishy, where he was certainly allegedly bullying and chastising the student. And so in January of 2015, the plaintiff twisted an ankle during physical education class, which turned out to be broken. This prompted the boy's parents to get the doctor's note, which restricted him from sports and other physical activity for about a month. But according to the lawsuit, the physical education teacher, Thurston by last name here, and other staff ignored this instruction. And so Um, Due to that, uh, the boy's parents found no other option but to pull the son out of the school, because they were um, convinced that he was, in danger due to the intentional acts of the teacher to, um, you know, place emotional and physical stress upon him. And so the lawsuit seeks unspecified damages from the school district for discrimination, civil rights violation, and emotional distress and other complaints. And so, um, again, this teacher is intentionally doing something to certainly cause emotional distress at the very least, if not physical. Um, and he found himself um, with a lawsuit against him. Again, I did not know the result of it, but I just want to show you that these things happen. And so when we talk about um, negligence and unintentional tort, well, this is actually what we see is most common when we talk about litigation and against schools. And so, most school law cases that pertain um, to breaches in tort law are often due to some form of negligence, um, which results uh, in a harm to another person or property. And so, um, negligence really means that failure to use ordinary care. And when you have to prove negligence, you have to prove a breach of duty. The plaintiff must prove by a preponderance of the evidence that the defendant failed to use ordinary care and do what a reasonable person would have done under the same circumstances. And we'll talk about that a little bit more and show you a real life example here in a minute. But the term loco uh, parentis, right? This means all educators, including physical education teachers, have a general duty to instruct, reasonably supervise, and protect children from known or reasonable or reasonably foreseen dangers while the children are under the teacher's care, right? And so sometimes, we see this in physical education where a student is hurt, as I mentioned earlier, previously, but there could have been something done to avoid that injury. And so when we talk about having to, prove um, any type of negligence or an unintentional tort, right? Well, really, there's, you know, four actions, four steps. A duty of care must exist, right? And so, in physical education, our duty of care would be to, you know, um, have a general duty of instruction, reasonably supervising and protecting children from dangers, right? So we do have a duty of care to students in our teaching profession. So that would have to be established. And then you'd have to show that the defendant had a duty to the plaintiff, which, right, physical education has that duty to ensure that care for the students. The defendant breached that duty, right? Maybe they weren't maybe they left the gym and then the injury occurred and this injury happened because of lack of supervision. So that was definitely a breach. The breach was both the cause and fact and legal cause of damages. So because of that, that teacher not supervising, that was indeed, the fact why that student got injured and caused the damages, right? It could be maybe, teacher left the room and a student got beat up by 5 other students, right? Well, maybe it wouldn't have happened if that teacher would have just been doing what he was supposed to or she was supposed to, and that these are provable compensable, uh, damages. And so you have to prove all 4 of those things, to um, fully prosecute any type of negligence or unintentional tort. And so let's look at another example. Again, here's another example where I couldn't find the outcome, but this was certainly a lawsuit and a big one for $5.5 million. $5.5 million. And this was Castrity versus Public School 183. And I couldn't find the actual name of the school district, but that's who the lawsuit was against, only the school. And what we actually see is it's pretty common for these type of negligent cases involving unintentional tort that the defendant, or excuse me, the plaintiff or the victim goes after the entire school district, rather than just the individual school when we're talking about um, you know going after monetary damages. And so this one, um, the plaintiff was going after the district. So essentially what happened was a third grade student was attending a school-sponsored after-school program under the direction of the school's physical education teacher, Lloyd Poland. And, this in this after-school program, they were happening to do some light resistant strength training exercises, and the students were using an elastic exercise band to strengthen their biceps. They were instructed by the teacher to pull up on the band while another partner held the other end with their feet. So they had a partner. One partner was pulling the band, the other one was holding it in place at the feet. When the plaintiff tugged on his band, his classmate, his partner, let go. And when he did that, the band hit him so hard in the face and left his eye with multiple injuries, resulting in substantial pain and loss of vision. The lawsuit claims that the teacher did not warn the students of any hazards or the importance of not letting the band loose, and they also did not provide any type of protective eye gear that would, could have been, which could have helped prevent the damage to the eye. And so, this is an example of an unintended injury, but the plaintiff, the victim, is suing the district for negligence, claiming that the teacher failed to use ordinary care because he had an obligation to warn the students of those foreseeable dangers, and he did not do it. And so this is where we talk about, we use equipment in physical education classes, whether it be a team sports class or a weightlifting class, right? That students need to understand not only how to properly use that equipment, but you need a solid set of rules and established consequences if indeed they do violate any type of um, rule. And so again, I didn't see the ruling, the final ruling. I was unable to find it, but again, these are just situations that you don't want to see yourself in. And so moving on, focusing on, how do you kind of avoid getting yourself in those situations? So, not to use a sport analogy here, but given our context of physical education, I will use one. In terms of avoiding negligent or unintentional tort, we want to talk about, the best defense is a good offense. And so, um, you know, um, assumption of risk is something that can be used, to defend yourself against a type of negligence, and it's a good practice. This is where, the plaintiff voluntarily assumes inherent risk of activities through participation or an expression statement. So the participant must know, understand, and appreciate any type of inherent risk. And to use our textbook example, um, we saw the example of instructing students in physical education classes to play flag football, right? Well, the level of contact and risk should be significantly adjusted from playing full contact football for safety purposes, right? So, the students, they don't really have an option to choose, right? The teacher has assigned them to do this. So therefore, as the teacher, you want to make the environment more safe. So and we could, say, flag football, or if your flag foot, comes off, you use two hands, right? No tackling. But you have a thorough explanation of what the rules and the expectations are. And even you could have at the beginning of the year or even beginning of the unit, have the students sign a copy of those safety rules, because it can help them prevent any type of injury, and documents that you have taken precautions to make the environment safe. And you could do that for, floor hockey, where you could maybe use, a foam stick rather than a hard stick, or a squishy ball rather than a hard puck, right? So you find these different ways to modify but the equipment, but you also, very importantly, you have a thorough rules explanation, and you make sure the students understand what those are. And so waivers and releases are good for, and are meant for, intended to shield the defendants from liability through assumption of risk, right? So you have these, maybe a signed document that maybe a parent or a student, they both understand the inherent risk that comes with physical activity, um, and you can go back and fall on this if injury does occur, because you've made them aware of that. And so That being said, though, when we talk about waivers, no waiver form can lawfully waive the defendant's responsibility to use reasonable care in supervising and protecting children from known or reasonably foreseeable harms. So, just because you have the student sign a waiver doesn't mean you get to, go back into the coach's office, pick your knees, or you kick your feet up on the desk and read the newspaper while the kids are playing. You still have a reasonable duty to supervise those children, give them general instructions, and help them avoid any types of danger. So you would still need to carry out, your duties to the child to ensure their safety. And so when we talk about some practical strategies, we can talk about different, risk management tactics. And so how do you keep, students and yourself safe? Well, here are a few good guidelines. Supervise the students reasonably, right? So you should never, ever, ever, under any circumstances, leave a group of students, or a student unattended, especially while they're under your care. Um, keep activities what we call developmentally appropriate, right? Well, you may have an activity where, you need students to be of a similar body type. Say it's you're doing a self-defense lesson in martial arts. You maybe not want to pick, the student who's 6'4" with the student who's 4'8", right? Because maybe you're teaching them how to, take a takedown with the protective equipment, and you do all the right things, but that person's force is just too much for the smaller individual, and it causes harm, right? So get somebody who could be around the same size, um, and so also a good idea to not only just group by sex, use those different types of body features that could be helpful. Keep the skill level too is important to consider. If you're teaching students how to overhand throw, and you've got a student who's on the baseball team who can rifle the ball 80 miles an hour, well, you don't want to put it up to the student who can't really catch that well. That could cause some damage to that student because they just don't have the skills to work with the other one. So knowing what the student's ability levels are a good way to kind of help keep them safe too. Provide spotting and other specific supervision and activities with risk, right? Especially with like any type of form of gymnastics, which is, it's a great unit to teach, especially with younger students who love to, do cartwheels and forward rolls, right? Well, they could be really hurt and in danger if you aren't monitoring them, right? Say a student's on, using their neck to do a headstand. Well, you don't want that to happen. And then they get hurt. So you always want to use some type of safety spotting. You can even have student spotting, where you teach the students how to do the spotting, and that helps as well, and also gives them some good information. Warn the students of any risk associated with the activity. For example, when I would teach floor hockey to in physical education classes to younger students, I'd have 3 rules. It was, you keep the blade of the stick on the ground at all times. You always leave 2 hands on your stick, and there's absolutely no body contact permitted. And those 3 rules were introduced at every single lesson. They were posted on the whiteboard, and the violation was the penalty box. And I talk about in hockey, you'd have to go sit in the penalty box if you committed a penalty for X amount of time. And so it was an educational opportunity as well, right? And so when I would see a student break one of the rules, I tell them, hey, Dr. Dayton, I need you to go to the penalty box because you only have 1 hand on your stick, and you'd go count yourself to 15 after taking a kneel in the penalty box, and you'd rejoin. So that's a good way to teach proper safety rules. Enforce the school rules too. I mean, school rules are there in general to not only enforce order in the school, but also to keep students safe. So if you see a student violating school rules, make sure you enforce them. This one definitely pertains to us in inspecting facilities and grounds for dangers, and to warn students of that. So if you're going outside with the students, you should be checking to make sure there's no broken glass on the field, or there's no sharp rocks that could really make them fall. And more importantly, you should also be telling them, hey, we're going out to the field. You need to be really careful. And if you see something that's going to be dangerous, please just discard it or get it out of the way, or let me know about it. Is a good way to make sure that keeping your playing area safe, because PE isn't just necessarily done in a gym. It can be done outside. it can be done in other settings. And so when you are outside, you definitely need to monitor the weather. I came from the lightning capital of the world in Southwest Florida, you know, where you cannot be, there have been people who have, and tragically who have died due to lightning strikes. Um, as a teacher, you want to make sure that, the weather is appropriate for the students to go outside. And so if you're talking about going out into maybe in the Northeast and it's too cold, there's probably a law that says in your school district of what the weather um, conditions should be to go outside. So if it's below freezing, you shouldn't be going out with the students. Or if it's too hot and say it's like August, September in the beginning, you shouldn't be going outside if your district or school doesn't allow it. And you always want to make sure, especially in hot conditions, that students have water and can stay hydrated. Always adhere to your emergency action plan. Your school will have one. Your district will have an emergency action plan, whether a student, has a severe injury, or it could just be a routine tornado drill. When these incidents happen, they should be practiced as a teacher and with the students as well. So when these, tragic things happen, that there is a plan, and if you're following the emergency action plan, it could help you in court. Make sure, especially in physical education, we talk about checking the equipment regularly. If you have faulty equipment, say you have a 7-iron and you're teaching the kids how to, hit the shot. Well, you've got one of the irons is really loose, and the student hits the ground, and that loose iron, because it was kind of damaged and you didn't replace it, causes a part of the club to ricochet off the ground and hit another student, causing injury. That could be very problematic for you, right? Same with like safety goggles or shin guards. If you've got those, equipment meant to protect the student's eyes or their shin in a soccer lesson, you should make sure they're functional. And if they're not, they need to be replaced because it could cause some damage. Keep records of student health and be aware of that. This is where collaboration is very important in a school. You need to talk to school nurses and figure out what the students, who, especially like who has asthma and who has breathing conditions, right? Because you want to make sure that if that happens, that you know who those students are, or that that you have a lesson that's going to be very rigorous and students are going to get very tired. You may already kind of be able, you have a good idea of who may have a breathing problem, and who you need to monitor a little bit more closely. And then certainly allow that student to, use an inhaler if they need be. And especially if you think, this is the biggest takeaway. If you think that you may be in trouble or you're worried about something, seek legal advice when you need it, and don't ever be afraid to reach out. Attorneys at the school want to work with you, or the district want to work with you, and they're the legal experts. They're going to tell you what you can do and what you cannot do. So don't ever be afraid to seek that advice when you think you may need it. And so I do want to make note that this was a presentation that was given by part of it was given by Dr. Thomas Baker and the Department of Kinesiology to HBA Health and PE majors last fall. I did build off this presentation and found some real life examples and use the content in our class textbook, Educational Law, Principles, Policies, and Practice. And so thank you for listening to my presentation, and I hope you found it useful.